Hello, my name is Michael Tesoro and I prepared this video case note on the case of ASIC and AMP Financial Planning Proprietary Limited, and this is one of the cases involving fee for no service. Bit of background about myself: I'm a competition and consumer lawyer and I run my own practice, Tesoro Legal Consulting. I've been doing that for 14 years and I help companies with competition and consumer law matters. Prior to that, I worked at the ACCC for 15 years in a variety of roles, including as Director of Enforcement. Outline of the presentation, I'll start with the background, then discuss the decision of Justice Moshinsky, and then finish with some commentary. Now, the background to the case, it involved this flexible super plan, which is being offered by various AMP entities. And under this particular plan, employers would pay for the provision of general advice services from various financial planners associated with AMP. And AMP would charge a fee, a plan service fee, for the provision of this general advice. The fee was automatically deducted from the superannuation accounts on a regular basis. However, when the members ceased being employed, they no longer had access to the general advice services, so they were no longer liable to pay this particular fee. The problem was that between July 2015 and September 2018, the AMP entities continued to charge members for these general advice services, even though they weren't being provided. And they deducted $356,000 from members' accounts. Now, each of the AMP entities were aware that the member had ceased employment and that no general advice services were being provided. Therefore, they should not have been charging any fees for a service they weren't providing. And people probably recall that this issue was highlighted during the Banking Royal Commission, the fees for no services that a number of entities were charging members. Now, the entities involved firstly was AMP Financial Planning, Hillcross Financial Services and Charter, and they all admitted to contraventions of the ASIC Act and the Corporations Act. AMP Life admitted to being knowingly concerned in the breaches by the advice licensees. And finally, AMP Superannuation Limited admitted both primary contraventions of the ASIC Act as well as being knowingly concerned in the contraventions by the licensees. So the issue that went to Moshinsky was really how large the penalty should be. So AMP admitted all the illegal conduct, but there was a disagreement on how much penalty should be imposed. ASIC claimed that the penalty should be 17.5 million, whereas AMP claimed that a penalty of 4.6 million was appropriate. Now, Moshinsky looked at the conduct and noted that there was no general advice being provided to the various members, and there was clearly no entitlement to charge the relevant fees. And the claim made by MP that it was really just the product of a computer coding error. And Moshinsky didn't accept that submission. He noted there'd been a number of complaints made to AMP by members about being charged this fee, and they'd responded by acknowledging the error and reversing the payments to the member, but they'd done nothing to investigate the systemic nature of the issue. He noted that it was only when they got to complaint number 14 that any steps were taken to investigate whether there was a systemic issue. So it went for a couple of years before any action was taken by AMP to get to the bottom of the problem. Now, looking at the number of contraventions, they're broken up into two periods. The first period is before the subject matter of the current case. So effectively, the prior contraventions were out of time and ASIC couldn't take legal proceedings against those. And then the second ones from July 17 to September 18 were the subject of the current case. And in the case, Moshinsky notes that there was agreement that the total number of contraventions was 51,835. But if you add up all the numbers on that page, it's actually 155,000 contraventions of the relevant legislation. And Moshinsky notes there were simply too many contraventions to really try to work out the total penalty based on the number of contraventions. Now, AMP had implemented a remediation program, and they had decided to remediate members from both periods, from the pre-17 period and the post-17 period. So the total amount that was refunded was $928,000 to 2,555 members. And in relation to the affected members, so the members who were subject to the proceeding, there were 1,452 of those, and a total amount of $691,000 was paid to them, including some additional component for the loss of performance on the fund. So they refunded the fees as well as a further amount for a loss of performance. Now here are the turnovers for the relevant entities, and it's quite interesting the amount of turnover. The thing that's really interesting, I think, is AMP Superannuation's turnover from 15 through to 18 has risen quite dramatically, from 7 million to over 900 million, so there's a big increase there. But the relevant period you'd probably be looking at for penalty purposes is 2018, which is the year that the contraventions ended. Now if you look at the turnover for each entity, you'll see there what they are: 469 million for the financial planning, 142 for Hillcross, 271 for Charter, AMP Superannuation 891, and AMP Life is the big one, over $4 billion worth of turnover. So the entire turnover of the entities which were subject to the legal proceedings was over $6 billion. Now it's interesting to recognise that the penalty amounts changed during the relevant period. Between 15 to 17, the maximum penalty was 1.8 million, and then in the period after 17, it rose to 2.1 million. So the judge looked at the various factors and concluded that there had been serious deficiencies in the way AMP had been managing its complaints. They were receiving complaints from various consumers about the problems, acknowledging the problem, refunding the consumer, but taking no steps to fix the problem. And the claims that it resulted from a coding error was not accepted by the judge. He said it was surprising that the problem had not been investigated much earlier. So he dismissed the minimisation of the conduct by AMP, describing the conduct merely as a coding error. He also noted that the corporate culture at AMP was very poor. The fact that they were unable to resolve the issue quickly reflected very poorly on the AMP entities, and he concluded that it reflected very poorly on the organisational culture of the business. He also concluded that the contraventions were extremely serious. There was a very large number of contraventions. It affected many different members. It was a wrongful deduction of a substantial sum of money from people that weren't receiving any services. The thing that he didn't mention was actually a fiduciary relationship, because these were effectively trustees for these members, so the breach of fiduciary obligation. He also noted the defendants were part of a very large group and they had not acted despite many complaints. He reiterated the question about, or the issue about, the delay in seeking to fix up the issues despite being aware of them. He concluded that the conduct was not deliberate but extremely serious. So then he imposed the penalties, and as you can see there, the penalties that he imposed. And in AMP financial planning it was 4.8 million, Hillcross 720, Charter 480,000, AMP 2.5 million, and AMP Life 6 million. Now, just to get some feel for how large a penalty that is compared to the turnover of each company, it's very, very low. As you can see, in relation to financial planning, it's 1% of turnover. In relation to Hillcross, Charter, AMP Super and AMP Life, it's less than 1% of turnover. That seems to be very small penalties to impose, and you have to ask yourself the question as to whether a penalty of less than 1% of turnover is going to achieve any specific deterrence or any general deterrence. It seems very much on the low side. And I think the observation by the judge that there was really very little point of trying to work out the penalty as a percentage of the total number of contraventions is fair enough, because as you can see there, even assuming 51,000 contraventions at 1.8 million, the number becomes so enormous that it doesn't have a lot of meaning. But even on that score, the penalty of 14.5 million would represent less than 0.1% of the total penalty available. So just some commentary here. I think the penalties are very low, and there's really no guidance as to how the judge worked out that 14.5 was an appropriate penalty. It's very hard to see how a penalty could be appropriate unless it's measured against some other factor. For example, against total turnover or the total penalty based on the number of contraventions. It seems very much that the number's been plucked out of the air. 14.5. Obviously, the judge thought 4.6 was too low and 17.5 was too high, so he's picked a number towards the upper end. But really, there's no real science behind the number. He's just determined 14.5. I think you can't be satisfied that a penalty of 14.5 is going to achieve any specific or general deterrence in relation to the conduct, because it's such a small proportion of the company's turnover. It is also concerning that there were gaps in the evidence which were noted by the judge, and really, if a case is coming to the judge and he or she's been expected to work out the penalty amount, the evidence has to be fulsome and complete. It makes the judge's job very hard if there are gaps in the evidence. It's also surprising that ASIC doesn't go for a lot more, because 17.5 might sound like a lot of money, but ultimately you've got to be asking yourself whether it's going to deter the company from engaging in such conduct in the future. And you'd think that they could have asked for a significant amount more money, particularly given they were taking action against 5 different entities. 17.5 against 5 different entities seems very small. As I said earlier, the judgment doesn't look at the maximum penalty relative to the turnover. It doesn't look at those factors, and that really leaves a question mark as to whether the penalties are accurate and effective. And one thing that's somewhat surprising is why the government seems to implement different penalty regimes for ACCC and ASIC matters. Recently, the penalties for breaches of the ACCC legislation has gone up to 50 million, 3 times the benefit, or 30% of turnover, but the ASIC penalties have not gone up the same way. So I don't quite understand the reasoning behind the government increasing the penalties on the ACCC side to such high levels and not also increasing the penalties for ASIC contraventions to the same levels. Really, the conduct's equally egregious and should be subject to similar penalties. So that's all I had. If you've enjoyed this video, please indicate you liked it on my YouTube site, and please subscribe. And if you have any questions about this video, please send me an email or give me a call. Bye bye.